I think we'll call the house to order here. As your permanent moderator in residence.
A lot of authority you have.
I know, right?
Never
Yeah,
have
just keep talking eventually. Okay, let me briefly introduce the speakers for our next panel. This panel is on agape and law. It's scheduled to run from 9:30 till 11. I think what we'll plan to do is add about 10 minutes on at the back end. Since you have full biographies, I won't sit here and read seriatim the full text. Let me just introduce briefly the three speakers from my right to left. First, we have Linda Ross Meyer from Quinnipiac School of Law. We have Michael Moreland from the Villanova University Law School, also suffering there as their vice dean, and David Van Drunen from Westminster Seminary in California, professor of systematic theology, also a minister in the Orthodox Presbyterian Church, and a lawyer, aware of many hats. So unless there's any reason to deviate from this, why don't we just proceed from right to left, and then we'll take some questions. Thank you.
Good morning, and thank you for inviting a stranger into your midst. Since I've mostly done philosophy and no theology, I'm more of a learner here than a speaker. I end up feeling especially that way after this last talk, because in many of the ways my talk is going to reach the same kinds of conclusions, I think, as Professor Matthew's beautiful talk, but maybe from a different direction. So we'll go with that. In the old role-play game of Dungeons & Dragons, one rolls the dice to determine the character traits of one's game avatar. One of the character trait choices is between lawful and chaotic, but a separate character trait choice is between good, evil, and neutral. We usually think that lawfulness and goodness go together. As Lon Fuller stated in his famous essay, Fidelity to Law, our naive belief as lawyers is that coherence and goodness have more affinity than coherence and evil. From Kant to Rawls, theorists have posited that humanity could achieve justice if only we were reasonable, universalizing our principles and treating like cases alike. The Dungeons & Dragons categories, however, suggest less intuitive possibilities. One may be a character who is chaotic and good. C.S. Lewis, in his Narnia series, suggests a similarly discomforting idea. Aslan, says Lewis throughout the series, is not a tame lion. One may also be a character who is lawful and evil. As contract high priest Grant Gilmore famously said, the worse the society, the more law there will be. In hell there will be nothing but law, and due process will be meticulously observed. Likewise, Lewis, in The Great Divorce, depicts those who want only their due going straight to hell and spurning the free bus to heaven. Throughout literature and law, we have many examples of lawful evil, from the compassionless bureaucrat at the DMV to the judge refusing to keep the court open 20 minutes longer to receive a request for a stay of execution in a capital case. But living with chaotic goodness is no easy matter either. If love is a kind of chaotic goodness, then as we've seen, yoking love with law is like trying to yoke chaos with order. Lawfulness requires, we say, treating like cases alike. Love, by contrast, requires treating each individual as infinitely important. Law is reason. Love is emotion. Law gives us justice. Love gives us mercy. Law gives each his due. Love gives what is not deserved. My resolution, which is at best an uneasy one, is to point out that human law can never and should never aspire to perfect lawfulness. We cannot be perfectly lawful because humans have to acknowledge their finitude in the following respects. First of all, our knowledge both of people and facts is always imperfect, both in the past and in the future, and time changes the facts even before we can discover them or as we're discovering them. Our ability to formulate rules is imperfect both because we can't foresee the future application of those rules and because we have to express our rules in the clumsy ways of human language. And finally, none of us can see the world clearly on his or her own. We see better, though still imperfectly, with the insight and perspectives of others. But the second point is even more important. I don't believe that we should aspire to perfect lawfulness, even if we could, for we would lose the human connections that make any commitment, including that to law, possible. As Reinhold Niebuhr says, if reverence for the law is the essence of the moral sense, as Kant maintained, it must be observed that reason may provide the law, but does not of itself furnish the reverence. Hence, in my work on criminal law, I've tried to advocate a vision of a humbler, more merciful law of criminal sentencing that would work within these human limitations by, one, acknowledging that no one's future character may be known by human means, and that therefore there should always be a sense of awe before the mystery of the other that tempers sentencing. Two, acknowledging that we live short lives, constantly in progress, and that time itself is not a series of unconnected moments, but has a special character that differs across a lifespan, and it should matter when we're sentencing. Acknowledging that even the past is changed in the present, so that even the character of a past crime does not remain static, as its reverberations are lived and its context is illuminated. Four, acknowledging that human selves are interpenetrated by community, profoundly unable to be monadic individuals, or, to borrow a phrase from Caleb Smith, cellular selves. And that therefore, the wrong of crime must always be understood as a rupture with others, which is always self-disintegrating for both the offender and the victim, and can be healed only through an ongoing process of atonement and settlement in community. What all this means on the ground for me is that criminal sentencing may never presume to reach perfect calibration of just deserts, but is amenable to only temporary resolutions and accords. Permanent judgments like capital sentencing, life without parole, and hard and fast limitations on appeals ignore these human limitations. As anyone who has worked in prison knows, every day of prison time is a struggle, if not for life, then for something more precious, the meaning or purpose of life. People do indeed change and repent and atone, but the eternalizing of time by retributive theory, both in holding the crime in an eternal traumatic present and by freezing the character and desert of the offender in the moment of the sentence, allows no change to matter. But for finite, relational creatures, time, circumstances, and relationships should matter in sentencing, so that efforts to change and atone should be part of what punishment is, and the needs of victims, victims' family members, and offenders' children and family should also matter in crafting responses to crime, which may not be imprisonment as payment. The overall movement of sentencing should be toward reunification and atonement, not just deserts. Restorative justice options like victim-offender dialogue, efforts to apologize and pay forward in meaningful and dedicated community service, treatment options may seem humbler and more appropriate to the relational and temporal character of being human than desert that's cashed out as freeze-framed years in prison. Human justice, I conclude, must be merciful and not absolute. So far, I haven't grounded my sentencing work explicitly in theology, but in philosophy, and I came to this conference in part to explore this new connection. Yet as I begin to read in the genre, I find that the same set of conflicts present in the theological dialogue are also present in the criminal law literature I'm more familiar with. In fact, far from seeing law as incompatible with human finitude, as I do, a strong strand of the discourse in theology focuses more on the ways in which love is incompatible with human finitude because we are so fallen and sinful. So let me start over on the other end of the tension, not with the limitations of human law, but the limitations of human love. Again, C.S. Lewis's lay classic, and as a layperson, I'm going to C.S. Lewis, suggests that human love, while pointing us in the direction of perfect love, is not capable of the universal regard and care that would ground a perfectly loving community. Though Lewis speaks of the defects of his four categories of human love in the personal context, it's easy to extrapolate them to the political. Storge, or the love of family, is a human love that has the virtue of loving the unlovely, like crazy Uncle Alfred. It accepts imperfections and is loyal and steady through time. However, love of family also has a human defect. It's tribal, it aims at no improvement, and it's stuck in the comfort of a familiar past. Translated to the political, Storge can ignore or demonize immigrants, relish anti-intellectualism, glorify and whitewash the past, and at its most virulent, create the conditions for reactionary tribalistic hate. Philia, or the love of friends, Lewis says, is a human love that counters some of these defects. Philia has the virtues of seeking mutual improvement and binding together strangers in a common venture. The defects of friendship, however, are arrogance and exclusivity, as the friend group often comes to think itself better than others who do not share the common ground. Shifting to the political, Philia presents the dangers of partisanship and arrogance or perfectionism. An occupational hazard of academics in particular, Philia is sometimes elitist thinking that presumes that outsiders are ignorant and prescribes to them before understanding them. At its very worst, philia promotes eugenics, demeaning forms of rehabilitation or reformation, and forms of aristocracy, all in the name of the betterment of society. Eros, or romantic love, Lewis says, is the human love that most closely approaches unconditional love. Unlike philia, it's not self-aggrandizing or arrogant, but profoundly humble. Eros wraps the beloved in an embrace of acceptance and appreciation of the whole person in integrity, not just those aspects that are familiar or excellent. And it seeks the good of the other person, even at the expense of self. But the downside is exclusivity, obsession, jealousy, and the danger that one will lose all perspective in pursuit of the beloved, sacrificing everyone, even one's own character, for love. Politically, the patriotic hero who gives his life for his country is the positive side of Eros, but Eros also comprehends the dangers of fanaticism and extremism, illustrated by the suicide bomber, the ideologue, the torturer, or the assassin. In Lewis's book, of course, agape is the divine love that perfects human love through God, so to avoid the defects of the forms of human love and enable their excellences. Is agape possible for human institutions? Lewis is skeptical. I'm only beginning to discover the long theological tradition that explores this question, but as we know, history has many examples of humans who have imagined with the best of intentions that they could embody agape in politics, only to pave a new hell on earth with what one writer calls a holocaust of generosity, with loving torture, loving castration, loving lobotomies, and loving imprisonment. Insofar as agape is possible for humans, it's possible as a form of receptiveness and humility. And I suggest 7 features of this agapeic openness for law. First, openness to other narratives. Careful attention to others requires the selflessness of love rather than the self-assurance of law. As many others have pointed out, listening carefully is an essential characteristic of judge, lawyer, and neighbor. One must listen with full attention to the whole person, to the whole client, as we heard yesterday. And in this way, agape bears all things and believes all things, listening without judgment, suspicion, or fear. Only after listening can you have a human hope of doing even human justice. 2, openness to the possibility of mistake. Familiarly, we all know about false confessions, mistaken eyewitnesses, botched lawyering, and lazy judging, and these are just a few of the many human failings that litter the law and make the office of judge a tragic necessity. Allowing in the law the opportunity to reevaluate our decisions and procedures that are open to opposing views are and should be key features of law. 3, we also need to have an openness to the possibility that we are wrong in a deeper sense. Lawyers in the last 2 centuries have found natural law bases and even biblical bases for slavery, apartheid, eugenics, sexism, and a host of other laws and rulings that we now find plainly wrong. It's possible that we will one day learn the error of our ways as well. The philia that often generates benevolent projects of perfecting others should be tempered by the agape that counsels awe before the other and humility in knowing what is best. 4, openness to the plight of the person affected by the law. Here, our particular judgments are usually better than our abstract ones. Law, in its pursuit of the general case, however, runs roughshod over the particular, but love looks to the individual other. Human law should be a constant dialogue between the framing of rules and their effects on real people. When, for example, a policy that allows publicly funded abortions only in the case of rape leads police to refuse cynically to report the rapes of homeless, mentally ill, or drug-involved women, or when a new law designed to control access to guns puts a father in prison for possessing an antique rifle that he's owned for decades, or when a law designed to punish murderers puts a 14-year-old girl in jail for life without parole for accompanying her boyfriend to a robbery, or when 2.7 million children have incarcerated parents, we have to pay attention and not merely look at this as collateral damage. 5, openness to the reality of risk and the certainty of failure. Law seeks regularity and security. The openness of agape reminds us that we cannot avoid being vulnerable and finite in this life. No criminal justice system can protect us from all crime. No contract can protect us from the vicissitudes of the future. And agape reminds us that we don't want law to eliminate risk. For a perfectly secure, pain-free life is one in which there is no room for surprise, grace, or law. 6, openness to a recognition that there are limits to law even within law. Agape reminds us that a perfect law is for the eternal robot, not finite humans. Agape opens us to the possibility of the inarticulable and the unrule-bound that are beyond law. For example, there is no reasonable within law justification for why we give special constitutional consideration to religion, though many have tried to find one. Though I wade shallowly in controversial waters here, it is possible that the genius of the First Amendment protections of religion was its acknowledgement of some sacred ground beyond the jurisdiction of law. Law must mark its borders. The same is true of other areas of legal doctrine that exclude rules and create pockets of what Austin Serrett describes as lawful lawlessness, the discretion inherent in the executive clemency power, the legal leeway and discretion accorded to prosecutors, sentencing judges, fact finders, policymakers, and lawyers that are making legal arguments. Like legal doctrine, legal practice is already shot through with a recognition of the limits of law. 95 to 97% of criminal and civil cases settle. And those are just the disputes that reach court. Few of us enforce our legal rights against each other, except in the most extraordinary cases. 7, and finally, openness to the preconditions of law itself. The basis of a social contract is a mutual commitment through time. The commitment to keep one's commitments comes before the first contract as a given. This promise to keep promises is itself a requirement of consistency, of abiding by one's words, following a rule, and being reasonable. The basis of reason is, in turn, an ability to recognize likeness and treat like as like. Hence, at the root of both law is contract and law is reason, there is a primary ability to see likeness, to see the not me as like me, and to have the will or desire to commit. That perception of likeness cannot itself be rule-bound, but is a gift or grace of who we are. Likewise, the human longing to live in a meaningful, lawful way is also a gift. To desire a relationship with a not me that I see as like me is like love. So law and reason itself, we might say, are based on the chaotic need to love, itself a given. In this way, the divine grounds law while pointing beyond it. As in Dungeons and Dragons, lawful good must at least humbly acknowledge the existence of chaotic good, even at its very root. Otherwise, we lose sight of law's humanity, as well as losing any glimpse of the wild lion.
Well, thank you to Bob and Michael and to Dana for their organization of this conference, which is a remarkable opportunity for lawyers and theologians and philosophers and others to engage one another, which leads right into the topic of my own paper, which is a lawyer's engagement, a law professor's engagement with the work of a prominent contemporary philosopher. I think one of the challenges in the law and religion field generally is that those in the law professor side often engage in working with philosophy and theology, but often do it by way of working with a lot of bad philosophy or bad theology, and vice versa on the other side. And so what I took the opportunity for this conference to do was to engage the work of Nicholas Walderstorff, who, just a 30-second bit about him by way of background. Walderstorff, as many of you probably know, was a longtime faculty member at Calvin College and then at Yale Divinity School, who was the founder of the sort of Reformed epistemology movement in the philosophy of religion, but over the last 15 years or so, moved very decisively to working in ethics and political philosophy, most prominently in a work called Justice that came out about six or 7 years ago, and then a subsequent book called Justice in Love, very pertinent to our topic here, and then most recently a shorter work in political theology called The Mighty and the Almighty. And so I wanted to say a little bit about the work Justice and his work on rights, and then how that ties in with love, and along the way offer some of my own criticisms, but which are predominantly meant by way of appreciation. But I think that some of the questions that he raises are profoundly important, even if I think some of the answers that he comes up with need further elaboration and work. So in Justice, the book that I mentioned he came out with about 6 or 7 years ago, he offers a framework for thinking about justice in a profoundly Christian vein that I think was a wonderful corrective to decades long of, I think, rather dry and abstract Rawlsian philosophical reflection about justice. And so on the justice piece and rights, I want to talk about 3 aspects of it that I think are important. One, a historical or historiographical dimension, and then a philosophical, and then finally a legal point. As a matter of historiography, I think Walderstorff's work has been remarkably important in helping remind us that the world did not start in 1700, and that there's a larger and important way in which Christian political thought has for a longer time been able to articulate, among other things, an account of rights that predates early modern English political philosophy, Hobbes and Locke, and the American founding. And what you get, though, is a predominantly secular understanding of natural rights following the wars of religion, but I think now there's a literature out there of which Walderstorff's work is a representative example, showing that that secular understanding of natural rights has to be regarded as much more complicated. So, for example, Jeremy Waldron's book on Locke and equality that shows that Locke was much more thoroughly theological in his arguments about equality than had been, I think, appreciated. Eric Nelson's book, The Hebrew Republic, which showed that it was an engagement with the Old Testament in the 17th century that led many Republican thinkers to appreciate the importance of natural rights. And this myth, though, that the world started in 1700 has, I think, been distortive in both sort of liberal and conservative ways. On the liberal side, so to speak, the account that you get from someone like Mark Lilla in his book, The Stillborn God, is that the rise of social contract theory and natural rights finally gave a secular foundation to politics that moved religion off stage. And then on the conservative, maybe for want of a better term side, I think you get this argument that the advent of natural rights upended the previous order of natural right or natural law. I think you get these distortions in various kinds of Straussian arguments and also from people like Bill Kavanaugh and Alistair McIntyre. And so what Walderstorff, I think, does so helpfully for those of us working at the intersection of law and religion on these issues of justice is that he gives both a scriptural and patristic account of natural rights, a controversial one to be sure, but one that I think has at least some plausibility and shows again the ways in which religious and theological sources can give an account of rights and justice in law that are not exclusively secular. And he doubles down on this argument throughout the book and forces us to confront the difficult task of understanding our Western cultural heritage. As I say, I do think there are some hard questions that might be raised about aspects of this account. One is, and I won't spend much time on this because I think it gets rather complicated, but he has an argument that eudaimonism, which traditionally includes Chuck's friend St. Augustine and Thomas Aquinas, that cannot serve as the basis of an account of rights. And so he tries to reground rights in a way that rejects, to my view anyway, much of what is strongest in the Christian political tradition and tries to refound it in different ways. And I think that's been subject to some criticism and debate, which I won't rehearse here, but I think is an important kind of open question left unresolved by the argument of the book. But I want to move on, though, also to the fact that he, I think, helpfully in this way, gives us a way of thinking about rights and their importance in Christian political philosophy that is very much, I think, under attack in certain quarters. As I said, people like Kavanaugh and McIntyre and you get variants of this in, I think, both Protestant and Catholic circles, have a deep suspicion about the language of natural rights, and that rights discourse is individualistic, secular, atomistic, and the like. And I do think that Walderstorff's work is a helpful corrective to that, even if I wish he would have mined aspects of the Christian political tradition for arguing for that thesis that he ends up rejecting throughout the work. Let me move then from that account of justice and rights to, for this present conference, the more important issue of how that relates to justice and love. And Walderstorff makes, I think, the helpful observation at the start, which I think in many ways is at the foundation of the topic as formulated for this conference by Jeff Murphy and others, that there's this supposed tension between justice and love, and how we might think about it in a way that either prioritizes one or the other or can reconcile one or the other. In Justice and Love, Walderstorff in the first few pages kind of sweeps away what he takes to be kind of modern alternatives to the love ethic. Eudaimonism, once again, comes in for a very hard time, and then also egoism and utilitarianism. He sweeps those away in the course of a few pages. He says none of them offers an acceptable rule as to whose well-being one may or should promote as an end in itself, and under what conditions. And so he defends this tradition of agapism as the alternative in which the basic ethical imperative is to love. And then he engages with, and we've heard reference to some of these authors throughout the conference so far, some of the leading, especially Protestant articulations of this love ethic. And he, I think, for my purpose, gives quite strong arguments for the inadequacy, especially of the work of Anders Nygren, who I think has had a kind of a lot of criticism over the course of the 20th century, but the Swedish bishop who wrote on agape early in the 20th century, and argues against Nygren's understanding, which still I think has some purchase in certain Protestant understandings of the agape ethic, that somehow love drives out justice, right? That love triumphs over justice, and that self-regard and justice are triumphed over by the love ethic. So as summarized by Walderstorff, the moral, he's summarizing here actually Nygren, the moral vision of the New Testament is opposed not only to Platonic eros, but to Old Testament nomos, that is, law and justice. In the New Testament, agapic love does not supplement justice, but supersedes it. The love of God for us and our love for the neighbor that God's love evokes in us are not only conceptually distinct from justice, but concretely incompatible therewith. We are not to love the neighbor agapically in addition to seeking to treat her as justice requires. We are to love the neighbor agapically instead of seeking to treat her as justice requires. And so Walderstorff's alternative to that, which I'm deeply sympathetic to, is instead to find a way of accounting for the love ethic and agape that can incorporate justice. And as he writes in the sort of end of the constructive part of the first part of the book, all along we have taken for granted that seeking to promote the good in someone's life as an end in itself is to love that person. We are now in a position to see that there is something else that love seeks as an end in itself. Love for another seeks to secure that she be treated justly by oneself and others, that her rights be honored, that she be treated justly. That is, you see here, combining the argument on rights from the Justice book with the love ethic of his second work, and saying that the love ethic is to care for a person in a way that acknowledges the rights for which he has provided an argument in the earlier work on justice. The idea of love that we need, he writes, if agapism is to be plausible in an ethical system, is an understanding of love as seeking both the good in a person's life and to secure that she be treated as befits her worth, to treat her as one does because justice requires, it is to love her. That is to say that justice and love and their obligations are mutually reinforcing and compatible. A few questions and then a practical application to the legal context in the few minutes I have remaining. One is that I just have to put my confessional cards on the table here. As a Catholic, I'm puzzled by the insistence, not really articulated, but let's say the downplaying of love as a virtue. Love as a virtue like St. Thomas would have articulated charity as a virtue. That is the form of other virtues, perfects and elevates other virtues like justice, but it seems to me that, at least conceptually, is a way that within my own tradition, love and justice have been understood to be compatible, that Walderstorff simply doesn't give much time to. Also, as I was saying to someone yesterday after one of the presentations, as someone coming from the Catholic tradition, I have to ask the question, what happened to reason? What happened to practical reason's apprehension of human goods and the way in which they can be attained, and the ordering of those human goods, including in and through virtues such as charity, and instead here you get love not as a virtue of how we understand and appropriate in and through the love of friendship with God, human goods, but instead love is kind of this free-form principle along with the principle of justice that we have to find ways of finding compatible. But again, those are by way of sort of confessional or theological ecclesial differences with the account on offer here. Finally, in the end of Justice and Love, Walderstorff gives an account of a problem, I think, that is of great salience to lawyers, which I think he diagnoses very well, but I'm left somewhat dissatisfied with how he resolves it, which just means that he's opened up, I think, an important agenda for people at a conference such as this. and that is the problem of paternalism. How do you account in an agapic love ethic, which, as the Jeff Murphy essay from which this conference sprung points out, where agape is not cuddly and seeks the perfection and the virtues of others in civil society, how is that compatible with liberal democratic notions of justice in which autonomy and equal respect mean that one should not seek the, at least not paternalistically, the perfection of others? And as Walderstorff articulates it, there are kind of two understandings of how we might think of this problem of paternalism, which again I think is especially salient for lawyers. One consists on bestowing on someone, without any decision on his part, that which one regards as enhancing his good, thus regardless of his views on the matter. The second consists of putting pressure on someone to decide to act in a way that one regards as good or right, or to refrain from acting in a way that one regards as good or right. And this is a deep problem for liberal political theory. As people such as Rawls so eloquently pointed out, that the problem here is that it doesn't appear then that you give equal respect insofar as deliberative adults have a right not to be treated as inferior qua moral agents. And if you are doing so in a way that's paternalistic by, say, prohibiting possession of pornography or the like, or illegal drug use, or multiply the examples, that sharpens the problem. And so that's where Walderstorff in that chapter comes in and argues for the compatibility of agapism and liberal democracy on his view, because there's an equality of political citizenship and the recognition of the importance of resolution of disputes by voting. But I just find this solution still somewhat uncertain and underdeveloped. I think that, again, he's put his finger, as he says at one point, on perhaps one of the most important pressing questions for the Christian love ethic in a contemporary liberal democracy. It's also, I think, related to problems of how we understand toleration, for example. Toleration, as Bernard Williams and others have pointed out over the years, also has this aspect of sort of impossibility about it. On the one hand, you say, even though I think you're wrong, I will tolerate your false belief on, say, a religious or philosophical matter. How is that consistent with a love ethic? And again, the liberal resolution, the Rawlsian resolution of equal respect seems to be at odds with a love ethic approach here. And so I think that the problem that Walderstorff has diagnosed and the theoretical background are all important and well stated. The question that I leave us with, and I think is a topic maybe for another conference, is how do we justify things like paternalism and toleration from within a Christian love ethic, given the liberal pluralistic values that we also live amid. So thank you very much.
I think this podium was built for shorter people. A major theme of this conference is Geoffrey Murphy's question: what would law be like if we organized it around the value of love, specifically Christian love, and thought about and criticized law in terms of that value? The claim of my paper is that we ought not to organize law around Christian love. Christian love is an improper category to apply to law. Since I suspected that most conference participants would be at least open to the idea of seeking to organize law around Christian love, I labeled my proposal contrarian. Judged from yesterday, I know that there are certainly mixed opinions among participants. To be clear about one thing from the outset, I am not suggesting that law should be loveless in every sense. What I argue is that we ought not to organize, think, or critique law in terms of Christian love, that is, insofar as love is distinctively Christian. To make this necessarily brief argument, I must identify the nature and purpose of both law and Christian love. I begin with law. When we consider law, especially the criminal law, Murphy's main focus, we are also considering civil government, or the state, since the state is the institution that ordinarily administers and enforces law. Thus, it may be helpful to briefly examine Romans 13, 1 through 7, the locus classicus for Christian theological reflection on the state. Among several important things in this text, it teaches that civil magistrates have authority as office holders instituted by God, and that magistrates are God's servants who bear the sword to carry out wrath against evildoers. One of this text's chief puzzles concerns how and when God instituted civil office and endowed it with such authority. Clearly, Paul is not saying that God was doing so through the very writing of Romans 13, 1 through 7. For Paul treats legal authority as something already existing. I suggest that if there is any text in Scripture that describes God instituting legal authority, Genesis 9, 5, and 6 must be it. Romans 13, 1 through 7 says that civil magistrates have authority from God to do good for society through bearing the sword and carrying out God's wrath against evildoers. Genesis 9:5 states that God himself will seek a reckoning from those who shed the blood of their fellow human beings. And then Genesis 9:6 explains that God delegates this work to the human community. Whoever sheds the blood of man, by man shall his blood be shed. This sounds precisely like the authoritative task of the magistrate described in Romans 13. Genesis 9:6, it seems, provides the theological background and explanation for Paul's assertions. In the big picture, therefore, in Genesis 9:6, God delegated authority to the human community to execute justice against wrongdoers. And in Romans 13, 1 through 7, Paul clarifies that this authority lies specifically with the state's magistrates. This connection between Genesis 9 and Romans 13 makes sense in light of the fact that Genesis 9:6 falls in the midst of the covenant God makes with Noah after the great flood. This is Genesis 8:20 through 9:17. Let me highlight three aspects of this Noahic covenant. First, it is truly universal. God establishes it with the entire human race, every living creature, and even the cosmic order. Second, its purpose is preservative. It never promises blessings of salvation, such as the forgiveness of sins, everlasting life, or the conquest of evil, but only blessings of preservation, aimed at sustaining human society and the natural order, and at constraining evil. To use Reformed theological terminology, this covenant concerns common grace, not saving grace. Third, the Noahic covenant is put into place while the earth remains. That's Genesis 8:20. That is, until the final judgment and revelation of the new creation. It is evident, therefore, that the Noahic covenant is God's means for preserving this whole world until the end of history. And one aspect of this preservative work is commissioning human beings to administer the law by executing justice against wrongdoers, a task carried out especially by civil magistrates, with great assistance from legal professionals, I might add. Is this administration of the law to be a work of love in any sense? Yes, indeed. It reflects the love of God shown in the Noahic covenant. That is, it reflects God's benevolence in sustaining the world, providing it with many good things, upholding a measure of peace and order in human society, and bringing relief to victims of injustice. And as God in the Noahic covenant shows forbearance in holding back final judgment against a sinful world, so presumably should the administration of law show considerable forbearance, or mercy in Murphy's terms, in not bringing down the full force of the law against every wrongdoer on every occasion. Thus, the administration of the law involves love in at least these senses: promoting the general welfare of human society, helping victims through the redress of injuries, and showing forbearance or mercy to many wrongdoers. I now wish to highlight two important implications of my conclusions about law in light of the Noahic covenant. One is that the state's work of administering the law is grounded in God's work of preservation through a covenant of common grace, not his work of salvation. The other implication is that this administration of the law involves the enforcement of retributive justice. This is evident from the fact that Genesis 9:6 is stated in terms of the lex talionis, the eye for an eye principle of proportionality. Whoever sheds the blood of man, by man shall his blood be shed. Now, by the way, I liked Murphy's suggestion in answer to a question that I asked him yesterday of retributive justice understood in terms of just deserts. The punishment should fit the crime. There should be a kind of proportionality. I take it that's really what the lex talionis is getting with, along with the idea that this just desert should be tempered by forbearance or mercy. These two implications, I believe, demonstrate why a distinctively Christian love is an improper category to apply to law. First, while the state's work of administering the law is grounded in God's work of preservation through a covenant of common grace, Christian love is grounded in God's work of salvation through the new covenant in Christ's blood, using the language of Luke 22. One way in which Christian love is distinctive is through being a response to and consequence of redemptive grace in Christ. As Paul puts it in Ephesians, be kind to one another, tender-hearted, forgiving one another as God in Christ forgave you. Walk in love as God loved us and gave himself up for us, a fragrant offering and sacrifice to God. Or as 1 John says, by this we know love, that he laid down his life for us, and we ought to lay down our lives for the brothers. And again shortly thereafter, in this is love, not that we have loved God, but that he loved us and sent his Son to be the propitiation for our sins. Beloved, if God so loved us, we also ought to love one another. Christian love, therefore, is based in and imitative of God's saving work in the new covenant. Law, in contrast, is based in and imitative of God's preservative work in the Noahic covenant. Second, a distinctively Christian love is an improper category to apply to law because while the administration of law involves the enforcement of retributive justice, at least in part, Christian love excludes the practice of retribution or just deserts. Most famously on this score, Jesus said in the Sermon on the Mount, "You've heard that it was said, an eye for an eye and a tooth for a tooth. But I say to you, do not resist the one who is evil. But if anyone slaps you on the right cheek, turn to him the other also." Christ's apostles echo this idea. Paul writes in Romans 12, "Repay no one evil for evil. Beloved, never avenge yourselves, but leave it to the wrath of God. For it is written, vengeance is mine, I will repay, says the Lord." In 1 Peter 3, Peter commands, "Repay no one evil for evil." Thus, while the Noahic covenant prescribes the lex talionis as normative for civil magistrates administering the law, the New Testament says this has no part in Christian love. I might note tangentially, though I can't elaborate here, that I believe these two characteristics of Christian love that contrast with the character of law are related. Christian love flows out of God's redemptive love for the Christian in Christ, and this love of God in Christ is a forgiving love that satisfied all claims of retributive justice against us. This, it seems to me, is precisely why Christian love, reflecting God's redemptive love, refuses to press the claims of retribution, but instead freely forgives. Now, in contrasting two characteristics of law with two characteristics of Christian love, I believe I have established the main claim of this paper. Law ought not to be organized around, thought about, or critiqued in terms of Christian love. To do so is to confuse the nature and purpose of the Noahic covenant and the nature and purpose of the new covenant in Christ's blood. It is to confuse God's work of providence and his work of salvation. It entails asking law to be something it is not meant to be, to do things it is not designed to do, and to forsake things that it ought not to forsake. I realize that even those who may recognize the force of the previous argument may be disinclined to believe it's really true because of the intellectual and practical difficulties it seems to entail. Murphy's account is attractive in holding that, while Christian love suggests that law should be reformed in certain ways, love and law can and ought to fit together harmoniously. Nicholas Waltersdorf's account, which argues that retribution has no proper place in either Christian love or law, has a similar attraction. My account, on the other hand, may seem to create an uncomfortable tension or even hostility between love and law. What are the consequences if God has authorized civil magistrates to administer the law in part by enforcing retributive justice, while God also requires Christians to practice a love that forsakes retribution? Are we left with some sort of Anabaptist or pacifist solution in which the state may indeed be appointed by God to accomplish certain purposes, but Christians should have no part of it? I reject that conclusion strongly for a variety of overlapping reasons. I have time, however, to sketch an explanation only in a cursory way. In the Gospel of Matthew, I noted, the Sermon on the Mount forbids the lex talionis most clearly and forcefully. But the sermon is not a political constitution or legal code. The sermon presents an ethic for the coming kingdom of heaven as it is somehow to be manifest already here and now. The state and the legal system it administers does not manifest this coming kingdom. The New Testament never describes it in this way. On the contrary, it describes the state in terms of the Noahic covenant, which concerns God's providential government of the world in its present form until the end of history as we know it. The coming kingdom of heaven breaks into this Noahic world in the midst of history, but does not, for now, replace it or take away any of its legitimacy. Christians live under two divine covenants, the Noahic covenant and the New Covenant. And they must fulfill responsibilities under both, even though I freely admit these respective responsibilities are sometimes in tension with one another. I cannot discuss here how to negotiate that tension. But I conclude by noting that just because Christian love is not to find institutional expression in the law, does not mean it can find institutional expression nowhere at all. Later in the Gospel of Matthew, in fact, Jesus illustrates how a retribution-spurning Christian love is to be embodied in the church. I have in mind his instructions, explicitly given to the church, for resolving conflicts when your brother sins against you, Matthew 18:15 through 20. Here the wrongdoer is not to receive retributive justice or be punished in any way, but is to be urged to repentance and to be forgiven, reconciled, and restored. Paul guides the church in Corinth in the same way in 1 Corinthians 5. The church is the institutional embodiment of a distinctively Christian love. So perhaps we've stumbled into the answer to Murphy's original question. What would law be like if we organized it around the value of Christian love and thought about and criticized law in terms of that value? Well, law would then be like biblical church discipline. And biblical church discipline, while mandatory for the church, is no business of the state. Thank you.
Well, we have 40 minutes for questions. Jeff?
The general question and specific question for David's presentation. One, David, your scholarship has spent a lot of time developing the notion of two kingdom doctrine, as your bio suggests, as well as the distinction between law and gospel. The general question is, does what you presented today necessarily dependent upon those two doctrines? Yes or no, I guess. And then my specific question is, it did sound a bit Anabaptist on the question of what about the Christian who's provoked by agape love is serving as a magistrate, where that is precluded from him, as I inferred you, from actually engaging in that as he administrates your understanding of the Noahic covenant.
Okay. I would say that at least, it seems to me, in my own mind, that the case I was presenting makes a lot of sense in some sort of two kingdoms framework. And of course, there are different versions of the two kingdoms. It's a very common category in both Lutheran and Reformed thought historically. It takes some different forms in different theologians. I have defended a certain version of the two kingdoms doctrine, and I've tried to do that in part by giving an important place to the Noahic covenant. And in part, it's, in the most important part, because I think this is how we ought to read Scripture. but I think it also has the practical benefit of addressing a common objection to a two kingdoms doctrine, which is that it leaves the civil realm, the public realm, sort of in somehow autonomous or morally neutral or somehow free from our religious responsibilities. And it seems to me that grounding that idea of a common kingdom or a kingdom of the left hand, there are obviously different terminology that's been used for that it helps to establish that this is in no way morally autonomous, morally neutral, somehow separate from our religious convictions. And so I think all of that is, all that's very much in the background of what I'm saying. I mean, I think that someone could probably go a long ways, could go with me a long ways in what I'm saying without necessarily feeling like that person has to embrace a two kingdoms doctrine in some kind of explicit way. But I think my main point is it's basically getting at a lot of the same burdens I've tried to express in my defense of a certain kind of two kingdoms doctrine. Now, with your second question, what I would say is that I do believe that the Christian, insofar as he or she is a citizen of a particular earthly polity, does have responsibilities under the Noahic covenant, which involve the enforcement of justice, which includes, as one aspect, I'm not saying it's the entirety of the civil or the criminal law, but one aspect of it is this retributive aspect, this kind of just deserts, that there are appropriate punishments that are fitting for certain crimes. And that insofar as the Christian is fulfilling those civil common responsibilities, whether as a civil magistrate, as a police officer, as a lawyer, and I think in a variety of non-official capacities as well. I mean, even as a voter in a certain respect, that the Christian has the obligation to support that work of the enforcement of justice, even retributive justice. But what I would say is that I don't think that itself is the carrying out of a distinctively Christian love. I think that is a form of love, as I tried to say in my paper. But insofar as there is a distinctively Christian love, and of course, if there's nothing distinctive about Christian love, and I'm not talking about the word agape. I'm not, as you can see in my paper, I'm not making a big deal about the term, because I think that can lead us astray pretty quickly. If you don't think there's anything distinctive about Christian love, that Jesus was simply reiterating or reinforcing or explaining further something that is already entirely true for reasons that are already present before he's on the scene, I'm not sure my thesis is going to make a great deal of sense ultimately. But I think insofar as there is something unique that Christ reveals about the love that he expresses in his work and the love which those united to him are to express, I totally forgot where I started this sentence, so but I guess the point I was trying to make was I don't think that carrying out of that responsibility of justice as a civil common responsibility is the playing out of that uniquely Christian love. And that what Jesus says in Matthew 5 about turning the other cheek, I don't think that is meant as a way to help the lawyer or the police officer or the judge to understand the civil responsibilities of carrying out justice.
Barry?
Hi. So this is also a question for David. So you lay out these two distinct realms, and in your paper you keep reiterating that the realm of Christian love is uniquely Christian, distinctively Christian. I want to know if you could spell out a bit more why love, it's still governed by an essentially Christian, or at least in an ideal sense, governed by a uniquely Christian normative framework, just not the framework of love. But the other more expansive reading is that the civil realm is a pluralistic space, where in fact different traditions, whether religious traditions or secular traditions, come together in a conversation. So that in fact, in that realm, the norms that get generated, it's not just that they're not manifestations of uniquely Christian love, they're not even necessarily manifestations of uniquely Christian norms. Now, they have to be acceptable to a Christian, obviously. But I wonder to what extent you see the civil realm as being, and it's not just a practically pluralistic space, which it obviously is, but a normatively desirable pluralistic space in the sense of being a place where these various traditions can come together and converse.
Yeah, thank you. It's a great question and obviously a very big question. If I can try to be as brief as I can, I would say that the position that I would take is that the civil realm is in some sense normatively pluralistic, as I think you put it. And I ground that in the covenant with Noah. In that, it seems to me that that what God has ordained there is that for as long as this world exists, there is to be a certain kind of common space. Right? There's no religious or ethnic kind of criteria that are given for participating in this Noahic covenant. So this commission to be ministers of the law, or to be fruitful or multiply, and the other things that are there in this covenant with Noah, are given for all people. There's no way to take yourself outside of this covenant as long as you're alive. You're in it, theologically speaking. Now, so that seems to me that Christians are obligated. So I, as a Christian, as I read the Genesis text, I believe that I am obligated then not simply to put up with a pluralistic world as something I have to do just because of the present exigencies, but something that I think is actually ordained by God, that God wills me to live at peace with all people as far as I'm able, and that I'm not expecting a confessionally Christian polity. I'm not trying to seek that. Now, at the same time, if I was following your question, I think someone might come back and say, well, this is still a very kind of Christian theological perspective on this whole thing, right? This is not something that I just derived from my neutral reason. And that's true. And so where I would see my own view kind of land is that I think we need something like a liberal polity, but I certainly reject the idea of liberalism as a worldview, liberalism as a comprehensive doctrine in a Rawlsian sense. I would see myself as a proponent, as a kind of liberalism, as a kind of penultimate liberalism, a modest liberalism, in that sense of a pluralistic public space. But I would see that through a Christian theological framework, and that because I do believe that there is a natural law grounded in God's revelation in this world. I do believe that there is this there is a universal moral knowledge that is there, that of which I don't have any great confidence that we're going to establish any kind of utopia through this, but there is an objective moral standard on which people of various comprehensive doctrines can potentially agree, practically, if not on an ultimate theoretical level. So a lot more to say, but
wouldn't that mean then that there are obligations of persuasion that Christians have in a pluralistic order that might themselves be required by love? Persuasion
yes.
based on reason with other citizens.
Yes, I would agree with that. I would say that Christians do have an obligation to be as persuasive as they can, and I would say to be, I think, can be kind of pragmatic in the way they try to argue for things. That we're probably less likely to garner some measure of agreement with people with very different comprehensive views by using more pragmatic considerations than higher level philosophical discussions. Not that I'm opposed to doing that. I'm just not sure how effective that's usually going to be. And yeah, I would say that is an expression of love in a sense. Again, maybe not a distinctively Christian love in the sense of those New Testament verses that I was reading, but in this general sense of a benevolence and a seeking of the peace and order of civil society.
Sure.
Yeah, just as a mild, friendly amendment, I think, to what David was just saying to Michael, and then a question I think for Michael. Stop picking on David. I think
Bring it on.
There are two sets of obligations, right? The Abrahamic covenant doesn't oblige you as a Christian in any way. It's entirely as a human, as a created, as a child of
I would agree with that exactly. Yeah.
So that your obligations under that are not Christian; they are just human.
Yeah.
The obligations to be a Christian, mobilizing your love, or trying to convince people of that, are more, in a broad sense, evangelical obligations to share to create opportunities. At least it looks superficially like opportunities for God to work in the hearts of other people.
Yeah.
So in that sense, there's a kind of weird interface at this way between the Christian evangelical duty and the human civic duty in a way, but they're still somewhat distinct, right? Because that's my friendly amendment.
Yeah. Yeah. I would say, and obviously there are a lot of constraints with the time of the paper, but yeah, I mean, I would, one thing that I would want to emphasize, and I think this is part of what you're getting at, is that it's not as if God's providential purposes expressed in the Noahic covenant and these redemptive purposes that we find come to fulfillment in the new covenant are just sort of two vacuum packs that they never meet in any real world sense. I mean, there is this larger unity of God's work in this world, and God's providential and God's redemptive purposes are interlocked in so many ways. And yet, in this sort of conference, we're thinking really about the institutionalization of law and what it's doing, and then I think the importance of making some of these distinctions seems important.
So my question for Michael was, I totally agree with your worries about Walterstorff on paternalism. But what do you think about paternalism? What advice do you have? You've been thinking about this for a while. You have 4 kids.
I think it's fine. I think that I mean, he's right about, and again, some of the discussion there is compressed in the book Justice and Love, but I think he's right about the importance of, for instance, voting, right? And this ties into what I was saying about persuasion. So, but otherwise, I just think that that at least a variant of the liberal position that is anti-paternalistic is misguided, and that law does have a purpose prudentially to bring people to virtue. And again, Thomas works this out in the Treatise on Law about its limits and not doing so suddenly and doing so exercising the virtue of prudence. But it seems to me that that a strong anti-paternalist view is not a sound one.
So we've had a few hands up.
For Linda, you were talking a lot about the virtues of discretion as opposed to law for you. I wonder what you say about the proposition that judges should exercise less mercy and the executive, the governor, exercise more with pardons.
Right. This actually, I think, is a question that might intrigue the whole panel, but I was sitting down with a federal judge a few weeks ago, and we were talking about the problem of sentencing, and the judge said, I hear from the public defender. He tells me all about the mitigating circumstances of the case. He says that I should give the defendant probation. Then I hear from the prosecutor, and he talks to me about the seriousness of the crime and all the harm that was done. And he tells me I should give 20 years. And then everybody stops talking and looks at me. And I think that, judges really struggle with that, right? So, if you were grounded in this view that there's sort of an absolute right answer to the question of just deserts, does that mean that you have a mandatory sentencing scheme and that, maybe you give the governor some leeway? Or does that mean that you let the judge sort of at the individual level where they've seen kind of the whole trial and all the facts and know a little bit more, have some of that discretion there? I think those, for me, are the interesting questions about this. And I think that the law gives that kind of space for, in my view, grace to have a chance. So I guess I would say that, in general, I think it should be at the judge level. I think that's where most of the good information is. I think that the pressures on executives, the political pressures on executives are just too great for that to be the best place to exercise mercy. But, I think if you take the view that I'm hearing on the other side of the table, that there is a right answer to just deserts, please let me know what it is, then you would think differently about that, I assume.
I assume I'm the one on the other side of the table. And I would, it was quick in the paper, but I don't think the judges are simply to be giving just deserts, and that's the end of the questions. That I do think that there must be this forbearance or mercy that tempers the full administration of just deserts. I mean, I do think just deserts has a play. I think that has to be there in the background. There is a punishment that fits the crime, and we need to make sure that we don't lose that sense, so we get some kind of disproportionality. Except that I would say that that this virtue of forbearance is actually, I'm sorry for the kind of terminology I'm using here, but I would say that's a Noahic virtue. Because I think what we see in that Noahic covenant is, it's interesting, it's not God promising, I'm going to cancel the final judgment. Or it doesn't say, I'm going to enact a plan of salvation in which I'm going to bring you through the final judgment despite your sin, or something like that. It's basically, it's the postponement. It's a holding back of the just deserts, we might say. And it seems to me that I hope it's the case that one could agree with my paper because I agree with my paper, and yet at the same time also very much sympathize with this idea that there needs to be this forbearance worked into the law. But at the same time, I'm not sure we're ever going to be able to get a nice, neat formula as to, how does that play out in this particular case. I think there's going to have to be some measure of discretion that's given to judges, which means we want prudent, wise judges, which is nice in theory. But so I guess I would say that I would see what I'm saying is very compatible with a lot of what you're saying. I would want to put it in this Noahic framework and maybe hold back from talking about this as some kind of a distinctively Christian love that we're talking about.
Right. Yeah, I mean, I don't really have a view about that yet, but it does seem to me that the idea that there is a just deserts out there that is a different question than whether we can know it. And I guess I'm definitely a through the glass darkly kind of person. So I'm of the view that if there is a just deserts that's appropriate, especially, once you get past the kind of general categories of crime and you look at particular individual cases, it's a lot harder. And so I think that in my view, you try to go for what works, what's kind of pragmatic, what settlement is going to be the best for reintegrating people into and creating a peaceful world, not what is going to be right. And if there is a right and a just, it's going to have to wait until after this world.
Yeah.
1 and 2.
I'm Mike Woodruff. I serve as general counsel in the Salvation Army. And so we have a great interest in the practical street-level application of some of these concepts. And it seemed to me that when we look at the book of James, and James says, like the Noahic covenant, addressing the human condition, not specifically the church or Christians, James says, if anyone lacks wisdom, let him ask of God, who gives to all liberally, without finding fault. Now you have suddenly a very broad statement that seems to me to point both the magistrate and the lay person, whether in a Christian tradition or another religious tradition, points them to a kind of relationship with God that is the unifying principle behind the two kingdoms kind of thought. In other words, some people say of the Salvation Army, are you about just works? Are you about salvation? I mean, what is this? It is a high, you can't integrate those 2 points without having a doctrine of God, with a relationship with God. He is the one that resolves these kinds of things. But I was intrigued by the point that you last ended on, and that is to say there may be a relationship between love of God and the seeking of wisdom that comes from God that speaks directly into this question of the dichotomy between these 2 kingdoms. So when you get to the judge and he's sentencing, is he doing it on his own? Is it just a relativistic exercise, or is this something mysterious and profound? I mean, Aslan is not a tame life. We are out of the box every day for every decision we make with every person we talk to. That was your point. Mm-hmm. I thought it was very well done. So my question, if I framed it, is do you see a connection between the doctrine of God that unifies some of these questions and the need for wisdom as it informs the concept of God?
Yes, I think so. I'm not sure if what I'm going to say is going to get exactly to all that you're thinking about, but it seems to me that that part of our doctrine of God is the idea of God as the creator of this world, and the creator of a world that is orderly and meaningful and purposeful. And of course, those are not things that are commonly accepted in the broader general intellectual culture, the idea that this world is ultimately meaningful and purposeful and all that. But I think one of the implications of that idea of God as the creator and sustainer of this meaningful, orderly, purposeful world is that there is a certain moral order to this world. And I think that I was just speaking at a conference at a church last weekend about the book of Proverbs and about wisdom. And so in part I'm answering this question in that light because I've just been thinking about these things, and that in the book of Proverbs, I think, it's not, the way of wisdom laid out there is not in terms of meditation on Deuteronomy or Leviticus. There are very few mentions of the law in the book of Proverbs, but it's very much in terms of having this perception of the way the world is put together, the way that the world works, the way that people interact with each other. It's not a foolproof, there's not an exceptionless kind of thing, but you have to get this kind of sense, kind of perception of the way things are. And on the one hand, there is this almost a sort of tension in Proverbs. On the one hand, you've got, the fear of the Lord is the beginning of wisdom. That's Proverbs 1, verse 7. At the same time, you've got this real sense that there's wisdom found even outside of Israel. There's probably some borrowing in the book of Proverbs of this Egyptian wisdom document. I mean, there's a couple of oracles later in Proverbs by Agur and King Lemuel. They're probably non-Israelites incorporated in it. So there does seem to be a certain sense in which I would say, yeah, that there is this kind of universal accessibility of a certain degree of wisdom, a certain perception of this natural moral order. And we can see this in operation among many kinds of people. It's not as if it's only people in our own churches that exhibit it. In fact, many people in our own churches, we think, don't really exhibit it very well. And so I don't know if this is getting at what you're saying, but it does seem to me that we actually have biblical foundation for saying, yeah, that there is a kind of order built into this universe that wisdom is called to perceive. And that it's not something that I as a Christian have some sort of, I have some kind of monopoly on that market, or my fellow Christians have that. And that's not to, well, I guess I'll just leave it at that.
Mr. Moreland, I think one way to think of it, what David has been saying is that justice is rational, but Christian love is not rational. It's because of what we've seen revealed in Christ, that we can love like Christ. You were saying, with respect to Walterstorff, what about the role of reason? I wonder if you might answer that question. Is Christian love rational? Is Christian love universal in that respect, or is Christian love irrational? And so, how does that relate to your remarks about Walterstorff?
Christian love, I think, is super rational, but that doesn't make it irrational. And that reason can provide the predicates for apprehending God's love for us, although the fullness of that revelation requires grace, requires faith. And it seems to me that there's a danger of this is just crass Thomism, right? There's a danger of
That's the best kind.
there's a danger here of flattening out those distinctions about reason's capacity to grasp God's revelation. That I think I think Nick Walterstorff in his books, I just think he doesn't. Perhaps because of his own reformed epistemological commitments, he doesn't kind of trace down those arguments in much detail. But I do think that this Thomist view, I don't think, is necessarily at odds with that. It just would insist upon certain distinctions that I don't think he's making. So,
can I just follow up real quick? One of the things that I'm struggling with is this sense of what to do with revelation, right? What to do with that moment of just like, whoops, sorry, we're turning everything upside down, and here comes God, right? And one can say that judges could always ask for that moment of inspiration, but of course, I would love to say that everything I've ever said was divinely inspired, and I don't think that's probably true. So, so the question, it becomes this kind of antinomianism versus nomianism, Occam versus Aquinas, and how do you and the folks that you're speaking of, Walterstorff and so forth, how do you figure out the connection, I guess, between giving someone their due, right, and loving them, and I can see one way in which you could legalize love, or make law some kind of set of rational principles, but then what do you do with that revelation, that overlove?
But again, it has to be worked out in context, of course, but that the mistake from my standpoint would be to understand grace not as perfecting nature, but as somehow abolishing nature. And so in a discussion, for example, which it does seem to me to be relevant maybe to instances of judging, that the order of love that we have through our natural affections is not abolished in Christian charity, and that would be the normative sort of Thomist view, but of course the Kierkegaardian view is, and I think a more influential view in Protestantism, which Walterstorff himself doesn't buy entirely, would be that actually it does demand equal regard, and that the natural orders of charity have thereby been abolished. And again, I just think that's a grace and nature argument that we've been at for many centuries, but where I think Zach yesterday was making some interesting and helpful remarks in that way. But this is a dispute within the Christian family.
Professor Meyer, I was originally resistant, perhaps, to your category of least have seen through the glass darkly. I don't get it exactly, but this is what I think is required in this instance, rather than saying, you know, based on these subjective feelings of love that I have, this is what I'm going to do. And so I guess I'm a bit more sympathetic to David's proposal over here, that this is not the category of Christian love, but it is something else, common grace or mercy, or at least you're struggling to understand the contours of justice, and it allows an examination of the humanity of the victim and the transgressor.
Right. Again, I think that the response that most philosophers and theologians have to the problem that you mentioned is to say, well, let's just leave love to the private realm. And, the public realm should only be about reason and justice insofar as we can discern it. And I think that at least the way that retributivism specifies what's required is, in my view, just deeply wrong about who we are as human beings. Because it seems to me that, if you say, for example, that it doesn't matter whether the crime occurred 5 minutes ago or 20 years ago, and it doesn't matter what you've done in the meantime, and it doesn't matter whether you feel bad about it or don't feel bad about it, you still deserve X, I think that's the wrong way to think about sentencing. And I think that the only way to get it, to change that view of sentencing is to get away from a retributivism that connects the wrong, the crime, kind of eternalizes the crime and eternalizes and doesn't look at the relationships around that crime. And it seems to me that love, in the sense of being attentive to relationships and being attentive to change and being attentive to remorse and regret and all of those kind of legal emotions, and being humble and sort of in awe of this person that you can't completely understand or judge or predict. I think those are aspects of love that should and are really important parts of judging.
But there are varieties of justice, aren't there? Retributive is only one. There's restorative and rectoral, and I mean, these other kinds of justice may involve some of the characteristics you're talking about.
Well, I think that sentencing has pretty much been talked about as retributive justice for a very long time. So, part of this is trying to understand how justice could be justice and also allow some aspects of what we used to talk about as love or mercy. So that's kind of been my role. And yeah, I'm maybe what you want to say is I'm trying to do a different kind of justice, and that would be fine if you wanted me to say that, but I think it does incorporate some of those aspects of mercy that we've left to the private realm. And I have to say, I think in that moment of discretion, I think there has to be some leeway to make those kinds of really on-the-ground individual judgments. In that time, there are times when judges just get somebody. They just understand them in a way that happens between when you talk to somebody, and sometimes you get people and sometimes you don't. And lots of times that causes, racial bias or gender bias that we really have to be worried about. But lots of times it's across racial and gender boundaries. And I've seen, for example, a judge judging someone who was of a different race and a different world, and suddenly the judge just got their experience. And, I think that there are moments when that kind of understanding happens, and I don't want to lose those moments, because I think that's where the sort of wild lion comes in.
Well, why don't we bring this to a close? I think lunch. No, it's not lunchtime yet, right? There's no, I'm projecting my. I've been working hard up here all morning.
You get to go first in line.
Well, let's thank all of our panelists.